to be here and happy to answer any questions.
Thank you all. Under Committee Rule 9, we will now question witnesses under the 5-minute rule. I will recognize myself first and then our ranking member. So again, I'll be recognizing myself right now for 5 minutes. My 3 questions go to Ms. Bohan, Mr. Wolfson, and Ms. McCutcheon in that order. Ms. Bohan, you talked about seeking clarity, consistency, and compliance, making compliance easier. The 2024 overtime rule had a negative impact on each of those things, though. And as an HR director, I would love to hear your experience performing your duties, and can you describe the challenges that a small bank like yours would face if the federal government were to finalize an overtime standard that caused a large number of your workers to lose their exempt status?
Thank you, Mr. Chairman. Sure. So in my bank, I have about 101 employees, and funny enough, 3 years ago, before they hired me, the bank didn't have a dedicated HR staff. So these types of issues, if overtime threshold changed, would actually roll up to the corporate secretary and president of the bank. And they're not, they don't have formal education. They're not formally trained in HR things. They use an outside legal counsel, which surely they would have gotten the update and made the appropriate changes. But I'm mentioning that because so many small employers, they often are relying on an office manager to make these decisions. And are we counting on them to make the right call? So I hope that helped answer your question.
Absolutely. Thank you. Mr. Wolfson, BLS reported in November that 80% of independent contractors prefer their current work arrangement to actually being an employee. In my home state of Pennsylvania, we've seen bipartisan support for a program around portable benefits, a pilot program being offered by DoorDash. This program allows independent contractors across the Commonwealth to access health, retirement, paid leave, and other benefits without risking their independent contractor status. Do you have any recommendations on how this committee could increase access to portable benefits without triggering any unwanted worker classification changes?
Thank you, Mr. Chairman. Yes, I believe that the Modern Worker Security Act is a great step in that direction. It would make it very clear that when a worker wants to receive that sort of compensation in a form of a portable benefits payment, and that the business that they are interacting with on an independent basis wants to put that money into the account, that those dollars do not count toward a determination that that business is in fact their employer. Under the multi-factor test that the Wage and Hour Division is currently using under regulation for independent contracting, providing dollars in a form of a benefit, even if that's what the worker wants, even if that's what the business wants, that is one factor that the Wage and Hour Division could use to determine that a worker is in fact an employee. And so a lot of businesses are afraid to do that because the worker and the business don't want the employer-employee relationship. They want an independent relationship. And so this opens the door for that opportunity. It's something that Governor Shapiro and the Democrats and Republicans have worked together in Pennsylvania to do, and I think it's a really good idea for us to take national.
Great, thank you. My final question is for Ms. McCutcheon, as is the case with so many laws and regulations. Oftentimes the smallest of businesses are the ones that are the hardest hit. They just don't have the compliance ability, they don't have the resources. So in your view, what challenges have small businesses faced when dealing with FLSA compliance in recent years?
Well, they don't have lawyers, and they often don't have HR personnel, so they're relying on their advice generally from their accountants who just don't know the law. So it's not wage theft when they make a mistake. It's more like forgetting to run one of 50 items through the automatic checkout at a grocery store. It's an oops. And if they do the oops, right now, there's no settlement of claims, there's no waivers, there's no affirmative defense like there is under Title VII. So what happens is they get hit with a sudden huge bill, and it means bankruptcy. I've seen it. That's my lived experience.
All right, well, thank you to each of you for those responses to my opening questions. I now recognize the ranking member for the purpose of questioning the witnesses.
Thank you, Mr. Chairman. Due to the relentless cuts to the Department of Labor's